Thank you very much, Meg, and thank you all for being here for what promises to be a very interesting panel on G20 and civilian oversight of the police. What I'm going to do is quickly introduce each speaker before they speak. They're going to have 15 minutes to speak, and then after we're going to have a Q&A. We're going to speak in the order that everyone appears in the program. So our first speaker is Andre Marin, the Ombudsman for Ontario. He's held that office since April 2005. Before that, he was the first ombudsperson for the Canadian military, a former director of the SIU, former Crown Attorney, and the winner of many awards. So, Mr. Marin.
Thank you very much for inviting me to present today. It's an honor to be here and take part in this very important dialogue. My function is to oversee Ontario ministries, agencies, boards, and commissions, with some limited exceptions. In that context, what brought my involvement surrounding the events of the G20 summit was the Ministry of Community Safety and Correctional Services conduct in relation to Ontario Regulation 233/10 under the Public Works Protection Act, the so-called secret regulation. That is why I investigated and reported on in Cotomy Act. Although my investigation focused on the ministry's promotion and communication of the regulation, my investigation confirmed that the Toronto Police Service was ground zero as far as the Public Works Protection Act for summit security went. Chief Blair wrote the minister on May 12, 2010, asking for a designation under the Act of reinforced policing authority along the outer security perimeter around the G20 meeting area in downtown Toronto. Although there had been speculation that it was actually the integrated security unit of the RCMP that had requested the regulation, the evidence obtained in our investigation confirmed it was a Toronto Police Services initiative. The ministry decided to take up the chief's cause and recommend that a regulation be adopted designating 3 gap areas along the security fence as public works, reinforcing the police authority to exercise powers under the Public Safety Security Act. The regulation was approved in a confidential cabinet session on June 2nd and passed the next day. And it was in effect from June 21st to June 27th, 2010. The ministry appears to have been well-intentioned in supporting the police, and in particular Chief Blair's request. It wanted to help the Toronto Police Service in its effort to protect foreign delegates attending the G20 meetings. However, its acquiescence proved misguided, particularly given the Act's history and its exceptional provisions. The Public Works Protection Act was a relic from the war, World War II. The Act grants sweeping powers to guards and police officers to secure a large array of public property, including streets, transportation, utilities, and government buildings. Anyone under the Act entering or attempting to enter a public work is required to identify themselves and state their purpose for entering. They and their vehicles can be searched without warrant. Individuals cannot be refused entry into a public work, but if they fail to comply with requests for identification and submit to a search, they can be arrested, jailed, and fined. They don't even have the option of simply choosing to walk away, as many found out that weekend. Pretty tough measures, which might make sense during the time of martial law in September 1939, but cannot withstand scrutiny in a post-charter world. Canadians normally enjoy the freedom of walking in public without fear that they will be arrested for failing to identify themselves or submitting themselves to physical search. They are entitled to express themselves through peaceful protests and be free from arbitrary arrest and detention. In fact, that's what groups like the Law Union of Ontario were quite responsibly telling prospective demonstrators through their websites and brochures and information sessions in advance of the summit. Ontario is unique in Canada in having a Public Works Protection Act. In modern times, it has only been used in limited circumstances, such as to support courthouse security. And prior to the G20 summit, very few, even in the police community, knew of its mere existence. But the ministry did not formally consult stakeholders such as the City of Toronto or the RCMP, with primary responsibility for the safety of delegates during the meeting about this regulation, nor did it advise social justice groups preparing for the summit that the government was contemplating issuing a regulation which would have significant impact on civil rights. Instead, ministry officials decided to pursue a deliberate strategy of keeping the regulation under wraps. Even after it was issued, publication of the regulation on the government's e-law website was delayed until June 16. While this publication satisfied the technical notice requirement, it did not provide any practical notice to the public that their civil rights were going to be changed during the summit. Social justice groups had no opportunity to challenge the provisions, as was done with the sound cannons, for example, purchased by the Toronto Police Service for the summit, or even to warn of the potential infringements on civil liberties that the regulation threatened. Some ministry officials suggested that reporters and other interested in summit events were responsible for scanning the turgid e-laws website, finding the Public Works Protection and the new regulation, and figuring out its implications. However, even if one had occasion to stumble upon the regulation, I'm not sure it would have done anything good. Its drafting was so technically convoluted that senior ministry officials couldn't agree on what it meant, and the police chief got it wrong too. Nowhere on the official summit website, which contained extensive information about the traffic plans for that weekend, was there any reference to the security or the authority being exercised under this measure. As a result of the ministry's strategic silence, the regulation acted upon was nothing less than a trap for the unwary. And the first one to fall into the trap was York University master's student Dave Vassy. On Thursday, June 24th, Mr. Vassy was detained and arrested by police outside of the security perimeters after he refused to provide identification based on the standard rights advice given to protesters during the summit. He was arrested at around 4 p.m., and I was quite impressed to learn how rapidly news of this event had spread among social justice community. Within the hour, the Law Union's Movement Defense Committee had issued an urgent warning on its website, summarizing the act and the regulation for protesters, and soon after other groups followed suit. Then the next day, the Toronto Police Chief, Bill Blair, mistakenly referred at a press conference to the expanded police authority under the regulation extending 5 meters outside the perimeter rule. This pronouncement added to the confusion surrounding its scope. Despite revised instructions issued by the Toronto Police Service to its officers about precisely where the extraordinary powers under the Act were meant to be used, there was ample evidence indicating that the Act was applied well outside the security perimeter, often miles away, to stop individuals, require identification, and submit to search. While those wearing black apparel were singled out, many people going to, from work, and even going home from shopping were routinely stopped and searched under the Act. The ministry's actions in relation to this regulation contributed to what I've spoken of as the most massive breach of civil rights in this country in modern times. And I'd like to take a few moments to explain why I've come to that conclusion. To begin with, the regulation itself was illegal. The purpose of the Public Works Protection Act is to protect public property. But the stated purpose of the regulation was to protect foreign dignitaries. In passing the regulation, the government appears to have exceeded its legislative authority. Secondly, the application of the regulation and the provisions of the Public Works Protection Act are of questionable constitutionality, given the fact that they appear to fly in the face of protected charter freedoms without any reasonable justification. When I issued my reports, I tried to downplay the effect of this regulation, pointing out that, only a few individuals were actually arrested under it. But this regulation played a huge role in the violations of civil liberties that occurred. Arrests are only a part of it, and they're a way to minimize the infringement. You can be arbitrarily detained in violation of the Charter without being arrested, and this was done by the hundreds. In the case of G20, police routinely stopped people under the Act who were not committing offenses and demanded that they provide identification and submit to physical search. They were not free to remain silent. They were not free to walk away. And if they refused to comply, they could be arrested. The police did not have the grounds to suspect that an offense was committed. They could just demand compliance. So it is not just a matter of counting how many were arrested, but how many individuals had their civil liberties infringed by being stopped under the Act's authority. And by many accounts, this number was extensive. And I bet many of this room personally experienced the application of the Act firsthand. The ministry added to the chaotic atmosphere accompanying the G20 summit by unreasonably supporting the Public Works Protection Act, and by being quiet about it, thereby putting unsuspecting citizens at risk. In this incendiary atmosphere of the G20, this was unconscionable. In my report, I called the government to take steps to revise and replace the Public Works Protection Act and recommend the government develop a protocol that would require public information campaigns when police powers are modified by regulation, particularly in protest situations. The government has agreed to the recommendation, and retired Chief Justice McMurtry is reviewing the Act with this in mind. My investigation and report into the G20 regulation highlighted what can happen when civil rights are subverted to other government interests. I'm hopeful that the legacy of the G20 summit will include reforms in how public officials plan for and implement security measures for major events, and that in the future, planning will be informed by principles of good governance, including the respect for individual civil rights. Thank you.
Gerry McNeilly, who was appointed as the Independent Police Review Director in June 2008. Before that, he served as a Justice of the Peace, Deputy Judge for 9 years as Executive Director for Legal Aid Manitoba. Mr. McNeilly is a founding member and chair of the African Canadian Legal Clinic in Toronto and a Woman's Place in Winnipeg. Thank you very much.
Well, thank you, Kent, for the introduction. As Kent has indicated, I am the Independent Police Review Director, a very lengthy title, but in any event, that's the one I have to use. My office, the Office of the Independent Police Review Director, is responsible for receiving, overseeing, and managing all public complaints against police in Ontario. That's some 28,000 police, there's 56 police services, and 156 OPD detachments throughout Ontario. We are a civilian oversight agency. Our role is to make sure that public complaints against police in Ontario are dealt with in a way that is extremely transparent, that is accountable, effective, and that is extremely fair to both the public and the police. So I want to give you a little oversight, a little overview into civilian oversight as the topic of this matter, as well as talk a bit about my systemic review in regards to the G20. Civilian oversight, in my opinion, is extremely important in society. Civilian oversight is one of the ways we can ensure that there are some checks and balances in place for those who wield power and uphold laws. Justice William O. Douglas, the longest-serving justice in the history of the Supreme Court, the United States Supreme Court, he spent some 36 years on the bench, put it this way: those in power needs checks and restraints, lest they come to identify the common good for their own tastes and desires, and the continuation in office as essential to the preservation of the nation. The idea of justice embodies the very fundamental social values of fairness and equality of treatment. These values, that when they are upheld, allow people to have confidence in the laws and the justice system, as well as trust in those who uphold those laws. I'm sure that you will agree that the police are one of the most central public services in a modern state. Police officers are granted enormous powers and authority in protecting and ensuring the fundamental freedoms of citizens and maintaining peace and order. These powers include, for example, the power to detain and the power to use force against citizens. When individual officers abuse that power and that authority, or perceive to abuse that power or that authority, it is a betrayal of the public trust in police. When the public believes that the police cannot be trusted, respect for the police and the laws that they enforce diminishes. Oversight mechanisms provide an important way in which policing can become more directly responsive to the public, and a way to ensure that freedoms and rights are promoted and are protected. Independent civilian oversight therefore involves people from outside the system or an organization, who are free of biases, who are neutral, who are fair, and who are possessed with a conscience to ensure the protection of rights and freedoms, taking a role to ensure that the system is held accountable for its actions, is held accountable for its policies and its behaviors. It also helps to ensure that services are delivered in a respectful, effective manner with a transparency, accountability, and equality. Civilian oversight helps to promote and maintain confidence in the system. And in the case of police services, civilian oversight helps to maintain confidence in the community confidence in police and policing. Because, in my view, the public needs the police and the police needs the public. I'm going to give you a bit of a history of the system of public complaints against police in Ontario. I think it's always good for us to remember how what we have today in Ontario came about. I'll also tell you about my office and how it works, and share a bit about my office in doing what it's doing in relation to the G20 summit in Toronto. Most civilian oversights operate by receiving and responding to complaints against police from members of the public. Where oversight mechanisms have been established, rarely have they emerged because of a consensus among police, among government and citizens advocate for their values. More often than not, they are the product of struggle and compromises made between those who sought oversight, who support oversight, and those who resist it. And between those two competing visions are what oversight should look like. In part, this all came about, in my view, because of the American Civil Rights Movement in the 1960s, where leaders such as the Reverend Dr. Martin Luther King created a heightened awareness among all North Americans, including Canadians, about their rights and their liberties. In 1970, there was a period of great unrest in many Canadian cities, and especially in Toronto. There were numerous conflicts between police and Toronto citizens. In those years, the tension was not just between police and visible minorities, but was generalized as various fractions of the community found themselves confronted by contradictions in their ideas of equality and justice and their dealings with police. As a result of these confrontations, many people from different walks of life and many organizations publicly protested. Individuals such as myself, yes, believe it or not, I was an impressionable teenager in those days, marching the streets of Toronto and the City Hall, holding placards and making noises, much like occurred in G20. We marched in the streets of Toronto to ensure and protect rights and to make those in authority, including governments, take action to address these issues. Citizens who had interactions with police during those years often objected to the treatment they received at the hands of police. They complained about the lack of objectivity in the handling of complaints and believed that neither themselves nor their complaints were being taken seriously. It was a perception that gave rise to tension and the belief that police no longer appeared fully accountable to the public they serve. In the space of 6 years, between 1974 and 1979, no fewer than 5 reports examined different aspects of the interaction between police and various segments of Toronto population. The general conclusions, all of them, was that the police complaints procedure was not working and needed a civilian component. In Ontario, changes therefore brought in by a public complaint system started to take shape or take place in 1978 when local boards of commissions of police, what are now referred to as police services boards, voluntarily adopted new procedures to deal with public complaints. Under this procedure, complaints against a police officer were investigated by the officer's own police service, and the chief of that service was responsible for deciding how the complaint would be handled and dealt with. The complainant could then request a hearing before the local board of commissioners of police, which had the power to recommend that the chief take further action. Still, the public, especially in Toronto, with its growing diverse population, wanting to establish and assimilate themselves, considered this procedure inadequate. Still, there was virtually no civilian oversight in the police complaint system in Ontario. In 1981, the provincial government enacted legislation that created an independent office of the Public Complaints Commissioner in Toronto. In 1990, that Public Complaints Commission jurisdiction was extended to the entire province of Ontario. In 1990 was also the year that the Special Investigation Unit started, and while both the Public Complaints Commissioner and the SIU Director were involved in civilian oversight, they had different jobs to perform. Mr. Scott here will tell you about the SIU and will give you some information into the work that the SIU performs. This system operated until 1997 when the government of the day replaced it with a system where complaints about police were made to the relevant police service for it to deal with. A bit backward step, if I could say. So the government went back to what existed to somewhat before. Ontario ceased then to have civilian oversight body investigating public complaints regarding police conduct and police services. Police complaints remain an issue of serious debate and concern. In 2003, the Ontario Human Rights Commission released a report that discussed racial profiling in the context of policing and a lack of confidence in police complaints mechanism. The report recommended public consultations on police complaints to ensure independence and effectiveness of the system. In 2004, the Ontario government requested the Honourable Justice Lesage to conduct an independent review of the public complaint system. While he was carrying out his research in 2005, he found an overwhelming consensus among the groups that he met. He then created a report and he made 27 recommendations. Those recommendations were turned into legislation and created my office. I was appointed the Independent Police Review Director in June of 2008. My task at that time was to set up a civilian agency responsible for receiving, overseeing, and dealing with all public complaints against the police in Ontario, one that would ensure that complaints were dealt with in a way that's transparent, efficient, accountable, and fair to the public and fair to the police. I put great effort into learning what needed to be done right. My office opened in October 2009. While I'm independent, of government, independent of the police and independent of the public. I carry out my job in an extremely consultative and collaborative manner with all those constituents. My role and my organization's role is not to get cops, it's not to side with cops, it's not to advocate or represent the public. Instead, it's to be neutral and unbiased, to be fair to police, to be fair to public. Our jurisdiction includes municipal and regional services and the OPP. Any member of the public can make a complaint. The Police Services Act gives me the authority to review all complaints about police and to determine who's going to investigate those complaints. The Police Services Act also gives me power to search and seize, the power to search police stations, places, cars, and officers' homes, as well as other places. It also gives me the power to direct chiefs of police in regards to services and conduct matters and how they should proceed with them. I'm just going to skip a few things so I can talk to you a little bit about the Police Services Act also gives me the power to audit police services management and the public complaint system and to audit police services boards. My office is currently in the process of conducting a systemic review surrounding issues of public complaints against police in Toronto regarding the G20 summit. The review will examine the systemic issues related to allegations of unlawful searches, unlawful arrests, improper detention, and issues related to the temporary holding facilities during the G20. It will provide recommendations to address issues of a systemic nature for the overall improvement of police practices in regards to the policing of future protests. We have received 400 complaints, and we are working through those complaints, and they are being examined, and there are many common issues. My review will be completed in a timeline to allow me to ensure that it's done efficiently and effectively. And I hope that my recommendations will be followed and complied with in the sense that they're given, in the way that they're presented by me. I'm now in my second year of operation. We have received over to date, about 6,000 complaints. One of our goals within my organization is to ensure that dignity, respect, and fairness characterizes the way we work and the way we provide police complaints services in Ontario to the public. We're working hard to uphold that confidence and trust in our mandated service. I'm committed, at the end, in conclusion, to using my office to build community confidence and trust in police and policing, because in the end, as I said earlier, the community needs the police, and the police needs the support and the cooperation of the community. Thank you.
Our third speaker is Ian Scott. Mr. Scott, since October 2008, has been the director of the Special Investigations Unit. And before that, he served 16 years as a Crown Attorney, was involved in prosecutions of the police, including successful prosecutions stemming from the killing of Dudley George. He also worked as a defense counsel. He writes widely on issues concerning police oversight, including the author of, most recently, the Police Services Act of Ontario and Annotated Guide. Mr. Scott?
I'd like to thank the women who are here. When I started University of Toronto in the early 70s, women were not allowed in Hart House, so you're here and I'm glad you're here. There are three areas I'd like to cover if I have time. I want to do a fast overview of the SIU, discuss the SIU's investigation related to G20, and then discuss what's happening in other provinces if we have time. Turning first to the SIU itself, in the late 1980s, there were a couple of high-profile police shootings of young black males in the Toronto area. This caused the government of the day to create the Race Relations and Policing Task Force, chaired by then Police Complaints Commissioner Claire Lewis. His 1989 report made a series of recommendations, including the establishment of an independent investigative team composed of police and civilian investigators in police shooting cases. One of the last acts of the Liberal government in the fall of 1990 was the passing of the new Police Services Act that entrenched into law the SIU. The essence of the SIU's legal framework has not materially changed from its inception. The legislation says that the government shall appoint a director who must be a non-police officer, and he or she shall cause investigations into circumstances of serious injury and deaths that may have resulted from criminal offenses committed by police officers. After an investigation, if there are reasonable grounds to believe that a criminal offense took place, the director initiates a criminal charge and the prosecution is carried out by the Justice Prosecution Branch of the Crown Law Office Criminal. The first director was a retired Superior Court judge named John Osler, who worked with a skeletal staff and a budget of $500,000. It had to rely on the OPP to do its forensic work. In its first year of operation, it had approximately 64 occurrences reported to it. Fast forward 20 years and the SIU is almost unrecognizable from its beginning. In 2010, it received 281 intakes and now has a budget of $7 million. It has 14 full-time investigators, half who come from a non-police background, and 37 as-needed investigators throughout the province to respond to calls in a timely fashion. It has its own forensic identification officers, and the largest category of cases in 2010 were custody injuries, which included 171 cases. When the unit started, it didn't investigate sexual assaults. That changed in 1992, and last year, the unit investigated 37 allegations of sexual assault by on-duty police officers. I've been the director for about 2.5 years, and Ken's already referred a bit to my background, so I won't touch on that. But since being the director of the SIU, I've laid approximately 25 charges against police officers, ranging from manslaughter to sexual assault and assault causing bodily harm. One of them involved an officer in the G20 demonstrations. I'd like to turn to the SIU's involvement in that area right now. There were 6 investigations arising out of the G20 involving the SIU. Remember, the mandate is serious injury and death. And serious injury is basically a defined term. In terms of how it worked in the G20, it basically turned out to be broken bones, fractures. All were triggered in this situation by bone fractures received by the complainants. The 6 investigations ultimately fell into 2 categories. In 4 cases, it was impossible to determine how the injuries were caused, and in 2, I concluded there was probable excessive use of force, but the involved officers could not be identified. Accordingly, no charges were laid. I issued a press release, a 6-page press release, on Wednesday, November 29th, indicating what the results were. And I'd like to trace, if I could, through the events that happened after November 29th, focusing on the Adam Nobody case. I should add that upon the release, I expected that there would be a lot of criticism of the SIU for not laying any charges. Little did I realize that my most vocal critic would be the chief of the Toronto Police Service. The police service that at that point had no officers charged with an offense from the SIU. Now, the problematic part of my press release was dealing with Adam Nobody, and it related to the notorious videotape that I think we're all familiar with in this room. This is what I said. The first allegation of assault by Adam Nobody is corroborated by a video recording that was uploaded onto YouTube under the title Toronto G20 Peaceful Protester Tackled and Roughed Up. It shows the complainant running from a group of approximately 6 uniformed police officers who took him to the ground. Once on the ground, a scrum of officers surrounded him while he was held face down. One officer can be seen holding the complainant's feet off the ground, while other officers appear to be holding down the rest of his body. The arm of one of the officers can be seen moving very quickly 2 or 3 times in a striking motion towards the complainant with a closed fist in the upper area of either his body or head. If one or more of those blows landed in the complainant's facial area, it would be consistent with the injury he received. At that point, the complainant appeared to be immobilized and not representing a threat to the arresting officers. In my view, these closed fist strikes appeared to be an excessive use of force. I then go on to say we can't identify the officer. Well, I was going to work on Monday, November 29th, and I was listening to CBC, and Matt Galloway started recapping an interview he did with Chief Blair, saying that the SIU had relied on a tampered and fabricated tape. And I have to say I was quite concerned. I mean, no one wants to be publicly appear to be a dupe. And I thought, well, maybe I had been duped by the videotape. The videographer at this point was anonymous. And for all I know, as I said, I did start at the University of Toronto in the early 70s, this tape could have been tampered with. It could have been inserting closed fist strikes. So I was quite concerned when I got to work. During the course of the day, I listened to the entire the entire interview with Chief Blair, and I'm going to refer to some of the excerpts in a moment. But quite clearly, his concern was a gap in the videotape. And let me refer to some of the interview which took place with Matt Galloway on November 29, 2010. Quote, "I've had that video examined. It's been tampered with. There are significant segments of that video that have been edited out. It's quite apparent, actually, when you're watching the video. And when the SIU is relying on tampered evidence, on essentially a fabrication as to the corroboration of their assertion there are reasonable grounds to believe, I think it really calls into question the quality of their investigation." Another excerpt. "But the evidence they're relying upon is false. It's been edited. There's a significant portion that has been removed. And I think that portion, removes any opportunity for a reasonable explanation of force that was used. And frankly, I would have expected more." Another quote. "What those officers were in the middle of, Matt, was arresting a violent armed offender, and of course the use of that weapon. It has been removed from the tape. But in the middle of that fight, the officers identify the actions of the individual I think would have been extremely difficult." Further on, quote, "Well, let's talk about the truth. Let's talk about some facts instead of tampered evidence. And that's exactly what we're dealing with." Finally, quote, I'm now quoting Chief Blair again, "The SIU director is not relying on their testimony or their evidence or the statements that they gave. He's relying for his corroboration on a doctored video. And frankly, I think Ontarians, certainly the police and all Ontarians, have a reasonable expectation that they will get objective and confident investigation from the SIU. Public confidence in the police. Public confidence in our criminal justice system depends on that objectivity, on the thoroughness and confidence of their investigation." So I listened to this entire tape, and I was interested to note that there is a 4-second gap. There's absolutely no doubt about that in the tape. And maybe their forensics department knew something about that tape that I didn't know. So the day was rolling on, and towards the end of the day, I get a phone call from Julian Faulkner saying, lo and behold, this anonymous videographer has appeared in their office. His name is John Bridge. He's going to swear an affidavit. The reason why there's a 4-second gap, so I'm told on the phone, was the police were coming after him. He shut off the video, and he turned it back on when he saw the Adam Nobody incident. He's going to provide us with an affidavit, and he's also going to provide us with the original footage. Indeed, that's exactly what we got on November the 30th. That's Tuesday, November the 30th, about 24 hours after the interview with Chief Blair on Metro Morning. And as a result of that, I reopened the investigation. On November 30th, we issued a press release reopening the investigation into the Adam Nobody incident. We, at that point, had a sworn statement from Mr. Bridge. He said under oath that he did not revise or edit any of the images posted on the YouTube video. He further said that the video had approximately a 5-second gap because he initially thought he might have to retreat from the advancing police, causing him to interrupt his filming. He also provided us with the original videotape footage, which I've come to learn, it's a learning experience for me, was of much higher quality than the upload on the YouTube video. So this led to an investigation, and through the analysis of the videotape, we managed to get some stills which indicated other people were taking shots at the particular time. But as we're doing this, we're now Tuesday of that week. By Thursday, lo and behold, the Chief of Police issues a news release stating that he had no evidence that there was any intent to mislead with respect to the videotape in question, and no evidence that Mr. Nobody was armed. He extended an apology to Mr. Nobody. It's interesting to note that no apology was offered to Mr. Bridge, who was falsely accused of tampering the videotape. No apology was offered to the SIU, who the chief had falsely accused of relying upon fabricated evidence. But we continued with our investigation, and it became a very interesting kind of dynamic between us and the Toronto Star. The SIU received a second video of the incident, which initially we provided to the Star, because as you may remember, the Star was covering this big time with front page news on almost a daily basis. Also on November the 9th, TPS provided the SIU with the names of 15 officers that might have been in the vicinity of the Nobody arrest, and we designated a number of them, interviewed them, But this provided no light. They could not either identify themselves, if indeed it was themselves in the video, or identify any of their other officers in the video. As a result of another name that was provided to us by the Toronto Police Service, we identified Constable Angela Bortani, and I charged him with assault with a weapon. The rich irony of all this is that the evidence that will support this when it goes to trial is completely unrelated to the original video. It relates to one of the other videos that came forward. Now, I'm running into some time difficulties here. I have to indicate in my press release when we ultimately led to the charge, I thanked videographer John Bridge for coming forward and sharing this with him. It was a courageous thing for him to do. A lot of people would have been afraid to have exposed themselves publicly with their name in those circumstances, and as a result, we never would have moved forward that case. I also thank the media and other members of the public who played a pivotal role in assisting in the investigation. I just want to give a sort of recap as to where we are with respect to the G20 matters. Constable Britannia has been charged with assault with a weapon. There's an ongoing investigation with the Nobody matter with respect to other police officers. And as a result of other videotapes coming forward in 2 other instances, we are continuing with those investigations. Now, I've got 2 minutes. I want to give exactly a 2-minute overview of what's happening in other provinces, unless Kent will grant me an indulgence that sometimes I'd ask for in courts. The SIU has been around, as we've indicated, for 20 years. The only other province that has an analogous system to the SIU is Alberta. It has an organization called ACERT, the Alberta Serious Incident Response Team. Slightly different than the SIU, but it does investigations of serious injury and death. They also are mandated to do corruption cases, which I'm not mandated to do. However, the way it's organized is that it's seconded police officers as opposed to non-police officers in the SIU case. There are pressures in the following provinces. I'm going to shut up in a minute. There are pressures in the following provinces. British Columbia, because of the Braidwood inquiry as a result of the Trubisky tasering. Manitoba, because of the Taman inquiry, which has led to tabled legislation. And Nova Scotia, as a result of an inquiry called the Hyde Inquiry, and a shooting on a reserve in Cape Breton. If there's any lesson to be learned, although I have to put Alberta in an anomalous category in this regard, if there's any lesson to be learned that I've learned in this, is that oversight is driven by crisis. Thank you.
The last speaker will be Roger Rowe. Roger operates a successful law practice dedicated to the pursuit of justice for economically disadvantaged and members of equality-seeking communities, mainly in the areas of family law, immigration and refugee, criminal law, and education law. Roger was a staff lawyer at Jane Finch Community Legal Clinic for 5 years before entering private practice in that area. He has appeared before all levels of court, including his successful representation of Mavis Baker in the landmark Supreme Court of Canada case. Mr. Rowe.
Thank you for inviting me to participate. It's kind of hard not to wear out your welcome when you're the last speaker of the day, but I'll do my best. I've been practicing law for 21 years. I live and work in Jane and Finch with my wife and children, and we support good policing. We're concerned about, and we have a pronounced police presence in our community, if you haven't heard. And as I hear you all talking about this G8 summit concerns, my first reaction is, what's the problem? We've been living with police excesses for a while in Jane and Finch and complaining about it publicly, and nobody will come to our rescue. The message is, this is what happens when the group that's being targeted is someone other than yourself, and you don't do anything, and then you run the risk that down the road you may be next. Is everybody reading what I'm saying? Yes. The nodding heads, thank you. All right, so we respect good policing and we need it. And Many of us who live in Jane and Finch would love to work with the police to get it. And for the most part we do, but we have concerns about another side of policing in our community that's called the Toronto Anti-Violence Intervention Strategy. The short form of that is TAVIS. And the police tell us that it's their meet and greet. They go into the community to do proactive policing and meet and greet the community. And we have some concerns because as part of the TAVIS mandate and this meeting and greeting, they stop civilians even if they're not engaged in any criminal activity, even if they're not suspects, and they write them up on these 208, they're called 208 community contact cards. And they record the person's name and address and race. And I've cross-examined a number of police officers as to why how do they determine who they're going to stop and write up under these cards, and why they need to record the person's race. If the person isn't being arrested, if they haven't been found committing an offense, if they're not a suspect, then why is this being done? And what's being done with the information? Well, apparently the information is compiled and put into a police data bank and used to formulate police policy. We're concerned about this because of the revelations of the Toronto Star inquiry. After the Ontario Court of Appeal ordered the release of 208 card data for the period of 2003 to 2008, that 5-year period. And their analysis found that a disproportionate number of blacks are subject to these stops. We became concerned that really racial profiling is being done under the guise of TAVIS, and it should be stopped. Residents of Jane and Finch did a demonstration at 31 Division, the police division in our area, and they presented a petition to the superintendent of police back in December of 2008, and it was reported in the media. And this is what the petition said. A lot of them were parents with children who had been stopped under TAVIS. We are committed to working with Toronto Police in order to create a safe Jane and Finch community. However, the actions of the police over the past few months have created deep wounds and built a culture of fear amongst our residents. Any parallels to G20? Nodding heads. Okay. The attitude and actions of officers, including TAVIS, towards our community have strained the relationship. Mothers are now scared to let their children out of the house for fear of violence and harassment. Our youth are currently more scared of the police violence than they are of street-related issues. The over-policing of this community has led to increased levels of targeting, harassment, racial profiling, and created a fear of persecution among residents. The serve and protect credo of the police is not felt in our community. Alarming is the brazen approach of individual officers. Witnesses have accounted for what they felt was questionable conduct and/or tactics. Citizens have described seeing or hearing abusive language, threatening behavior, the excessive use of physical force, unfounded allegations, coercion, and torture. City TV was there, and this was reported in the media. A further concern of ours is the deafening silence of the public. To this, and also to the revelation of the Toronto Star inquiry into the use of the 208 community contact data and the overrepresentation of members of the black community in those police stops. We're further concerned because the chief of police, Bill Blair, has admitted that the overrepresentation of blacks in these stops, these 208 card write-ups, is attributable in part to racial profiling. And he admits that publicly, and where he's quoted saying that is in the Toronto Star article of February 6, 2010, when good people are swept up with the bad. And I quote, "We're not trying to make any excuses for this. This is Police Blair. We recognize that bias in police decision-making is a big, big issue for us, and so we're working really hard on it." Okay.
Get rid of him.
We should all be concerned about this. Today it's us and tomorrow it might be you. I've said that already. But in terms of a bigger picture, we're here all talking about police accountability. Our tax dollars pay their salaries and they owe us accountability. We shouldn't have to ask for it. Racial profiling is a waste of taxpayers' money. It's been shown to be and demonstrated to be ineffective as a police strategy, and there's no place for it in a democracy. Thank you.
Lots of time for questions. So I'm sure you'll understand, particularly with Mr. Scott and Mr. McNeilly and Mr. Marin, that there will be some things relating to individual complaints, individual cases before the courts or investigations that they may be restrained, but all of our panelists want to participate in the Q&A, and so I invite all of you to ask them questions.
Hey guys, how you guys doing? My name's Derek Sobral. I also grew up in Jane and Finch. And I know what it means to go through adversity, and this G20 event woke up a lot of people. We're calling for transparency and accountability. And my first question would be about the name badges. How a lot of these officers removed their name badges at the event, prior and during. So accountability right there was lost. We have cameras. Those are our weapons to capture the truth. And to see attacks happen on the ground, Canadian citizens want to capture those events and make people accountable. So I don't think they should be Velcro. I think they should be sewn on, and I believe it should be mandatory. So I just want to get your opinion on that matter. And I know that the police union tried to pass an act to actually make it unmandatory. So they wanted to have anonymous, no name badges. That's after G20. That's unbelievable. You know?
Well, as you may have gathered, I hold no brief for Chief Blair, but I have to give him some credit on this. He's the one who got the internal directive many years ago. And before that, there were no badges. Unbelievable when you think about it. So he does deserve some credit in that regard. I got to tell you, it would have made the SIU's life a whole lot easier had there been easier ways to identify the involved officers. So I concur. Maybe others that want to comment, I'm not sure.
I'll just say I agree with Ian that for those who know that Chief Blair has already indicated publicly that he has disciplined some 90 officers for not wearing a name tags. I can tell you my systemic review looks at anything that's systemic, and if that's a systemic issue, it will be looked at in my systemic review.
Yeah, I concur too, but I just want to say that you have to question why an officer, proud of the work they're doing, protecting the public, would feel the need to conceal their name. What's that really saying? You know who I am and what I'm doing and what I'm saying, and I stand behind what I'm saying to you, whether you like it or not. And we're paying these officers to protect us, and they should be proud of the job they're doing. And if they feel the need to have to conceal their name, I think that's saying something.
A couple of questions. First of all, in regard to the allegedly altered tape, if someone told Police Blair this with little or no evidence, it would seem to me that that would be evidence of obstruction of justice. And I wonder whether there has been an investigation for obstruction of justice in this case, or whether there should be, in your view. Secondly, Ian, I wish you had talked today about the stonewalling of your office that was reported a few days ago in the newspaper, because it seems to me that that's intimately related to what happened at the G20. As long as the police know that they're not accountable to the SIU or to Gerry's organization or to the Ombudsman, this will continue. Could we or should we have legislation that makes it a requirement to wear your badge? Or should we or could we have legislation that requires the police to give statements to the SIU, or would that offend the charter? Should we have legislation that requires the police to report to the SIU within a specific time period, instead of all these guidelines and policies and other non-legally binding instruments?
Minister? Yeah.
Sure.
I think Andre may want to have a few words on this one. That's a multifaceted question. If I can deal with some of them. First of all, with respect to the tape, the mandate of the SIU is to deal with serious injury and death. It's really not my mandate to deal with allegations of obstruct justice. So, and I believe I have my plate full. I'm not really looking for more work, notwithstanding the police think I am. So I think I'll leave that particular issue about the tape. Going on to the stonewalling issue, first of all, witness officers are compelled under law to give us statements. And they do. That's not a problem. Subject officers, those who may have caused the injury or death, have no obligation to give us statements. That's not going to change because of the charter. Just like anyone else in our society that's alleged to have committed a criminal offense, they don't have to give a statement. Now, a number come in and voluntarily give us statements. But the risk they take is that statement could be used against them if a criminal charge is going to be laid. Now, what the article in the Star was talking about was really at the end of the cases. As I indicated, we had about 280 cases last year. If a charge is laid, it goes into the criminal justice system. And there will be a public airing of that through the court system. I only laid, I think, 10 charges out of 280 cases in 2010. In all of the other ones, I write a reporting letter to the Attorney General, and I write a letter to the Chief indicating indeed no charges were laid, and I will point out in the letter where there have been, in my view, breaches of the SIU regulations, and sometimes issues that arise about training and other disciplinary issues. And what I've asked the chiefs to do, and the commissioner of the OPP, is to look into it and send me something back. Simply tell me what you did. I'm not asking that police officers be hung up by the yardarms every time I put something in the letter. I'm just trying to get some feedback because I don't know what's going on. And I do know these issues do recur. So yeah, this is an area that I'd like to see some reform in. But I'd like Andre to speak about this because I think it echoes some of the recommendations he made in his 2008 report. Sorry, I'm here.
When I started my opening earlier, I mentioned about how I oversee the agencies, boards, commissions of the entire government. So in that sense, I oversee the SIU, and what Ian is mentioning is something new, a practice that he adopted early when he was appointed director of the SIU, which is consistent with the recommendations we made at the time when we did our SA investigation called Oversight Unseen. And we were concerned when we completed that investigation, the SIU was not blowing the whistle on police who are not cooperating with the SIU. So we made that recommendation that the director follow through with those police agencies. Now, we are now conducting a second investigation of the SIU that deals with several aspects, including that one. So I can't really comment directly on that point, except to say that I read the paper as well a few days ago, and I saw that there was comments by the SIU that were consistent with what Ian is saying today, that the police forces are thumbing their nose all too often at issues being raised by the SIU. And I think that we need to, in that respect, instill some consequences in police agencies that simply decide not to abide by the law. As Ian mentioned, they are compelled to cooperate. And when they don't, and it's raised by the director of the SIU in a letter, there should be some kind of a consequence. And right now, all too often, they are ignoring that. One of the recommendations we did make when we investigated the SIU was that the director of the SIU should have standing to initiate action against individual officers who don't cooperate or against police services who don't take action against their members. And that is still sitting, gathering dust on the shelves. So those are all areas that we will be revisiting in our second SIU investigation and seeing why the Ministry of the Attorney General, which is the reporting agency of the SIU, why it hasn't acted yet on those points which are extremely important to the operations of the SIU.
And thank you to the Law Union for providing this opportunity. I witnessed civil liberty violations at Queen's Park in the late afternoon on Saturday, June 26th. I called your office, Mr. Marin. You found a way to get involved, and thank you very much. Mr. McNeilly, I wrote to your office. I had experience before with the prior institution known as OCOPS. I lived for 17 years in rural Ontario where repeatedly myself and members of my community's charter rights were violated. Professional Standards Bureau of the OPP ignored that, so did OCOPS, and my belief is this created a culture of where police feel they can do what they want. In my complaint letter, which you thanked me for very much but didn't do anything about it, what I cited was I witnessed members of the police forces, Toronto police are taking too much blame for this, inflicting head injuries on people. Mr. Scott, I don't know if a brain injury is a serious injury. Quite often it's not a broken bone or a death, but it's a lifetime impairment. So I'm going to ask you gentlemen to revisit my case and implement some kind of remedy of justice for somebody like me. I'm too young to feel that these things don't matter in my country. Mr. Rowe, I want to tell you, you don't have to live in Jane and Finch to be a target of the police. Thank you.
Yeah, if I could just very briefly comment. Yes, indeed, brain injury does fit under the definition of serious injury. And if a complaint came forward, it would be investigated. The way the complaints came into the office, the 6 that came into the office, where these were individuals who were arrested and they were injured at the time and taken to Toronto East General. And that kind of triggered the reporting function to the SIU. Now, we do have individuals that come to phone the SIU quite separate and apart from the police function. The way it's supposed to work, and it's right in the Police Services Act, in the regulations, which if there's a peer to fall within the mandate of the SIU, the police are supposed to report it. It can come in other ways, but I would say about 95% of the caseload of the SIU comes directly from the police services themselves. And that's an issue that has arisen. It came up in the Toronto Star article, which is the delayed notification issue. Obviously, we want to be notified as early as possible.
Just a comment. Thank you, ma'am, for indicating your concerns about this whole area. And that's one of the reasons why, under the auspices of my organization, I've in fact called a systemic review. While I've received some 400 complaints, and while I'm not acting on all of them in a complaint manner, each and every complaint is being considered and being used as part of my systemic review. So, ma'am, the letters that you would have written me and the complaints you would have filed with me, even if we may not be acting upon them, they are being acted upon as part of my systemic review.
This is the G20 fiasco. From the beginning, we heard all kinds of evasiveness, squabbles, and the blame game. And this is going on, really. We found a couple scapegoats, and we have quite a few action suits, but this does not solve the problem unless we have either an agency, an independent agency or service to initiate a public investigation. Otherwise, this will go on, will get the dirt under the rug, and this will be a repeat performance later down the road. Unless we know who is accountable, responsible, because accountability does not stop at the top. It trickles down all the way to Joe Blow. And unless we know who is at the top, responsible and accountable, and then we can go on and have some progress. Otherwise, civil rights will be again abused and no solution will be responsible. I don't know if this is Mr. Marin's department or not, but somehow an independent public investigation must take place so this will not be a repeat performance.
I could just say that part of me carrying out my systemic review is that one of my roles is to act in the public interest, and I call that review as I'm authorized under the legislation because I saw and observed and received some 400 complaints that told me there was something of a systemic nature taking place. So I am in fact doing that review, ma'am. It may not be a public inquiry because I'm not charged with the authority to hold a public inquiry, but I am acting in accordance with my legislation to look at this matter and the policing around issues around G20, and I commend you to read my report when it comes out in a short feature.
I agree there should be some sort of civilian review and inquiry and report done. My concern is, it's not that I'm wishing this or that I agree with this, my concern is that even if that report gets done, and even if the strongest of recommendations are made, history has shown us that there seems to be a culture of complacency in the public for police excesses. I don't know why, but it's troubling because this G20 thing, it's going to happen again, and somebody's going to get killed, and people just aren't getting it for some reason, and I don't know what it's going to take after today. I mean, what's going to happen next? Maybe there'll be another report, maybe there won't be. There have already been a lot of really good reports, going back to the one mentioned of Claire Lewis complaining. I remember driving down the alley about 20 years ago and hearing Claire Lewis on the radio saying that police are shooting unarmed black children. And I almost had to pull the car off the road because I couldn't believe that someone that reputable was being that honest and is being broadcast publicly. But 20 years after the fact, we're still dealing with the problem of police excesses, and we have a much stronger SIU unit, but still, police aren't cooperating with it, and we're still complaining about it. And so I'm concerned that even if we provide what this lady rightly just asked for, in the end, I'm concerned that it may not change anything because of the culture of complacency amongst most people, that if police are exceeding their authority, the person that they're passing on probably deserves it, and the police are probably justified in doing it. And I think we need to sort of shape that kind of view that's out there.
I have a couple of questions on police accountability for Ian Scott, please. The first is, anyone who attended the G20 demonstrations that weekend knows that there must be hundreds, if not thousands of hours of police videotapings of the demonstrations. Did your office have access to those tapes, and if not, why not? Second question, the letters that you spoke of that were described in the Star article this week to police service boards after the conclusion of your investigations, the Star said that the names of the boards, the police service boards themselves, were blacked out. Can you tell us who redacted these documents, and if you think that was justified?
Thanks. Just going back to the first question, my investigators did ask in every case if there was relevant videotape from the Toronto Police Services. Now, did they independently review the literally tens of thousands of hours of videotape? No, they didn't. We just didn't do it. We didn't have the resources to do it. But we did get some, particularly CCTV surveillance videos that are hooked up at Queen's Park, and are there actually all the time. They're not even Toronto Police ones. So there were reviews of videotapes. And they did enter into the piece, and ultimately, obviously, the videotape that was shot by John Bridge, which was not a Toronto Police Services one, was of relevance. The second question, with respect to the letters and blacking out, no, I did not black out the letters myself. The way it works is this: because we are part of the Ministry of the Attorney General, something that Andre has spoken about in his 2008 report, which means that all of the FOI requests, that came under a Freedom of Information request. We assemble the documents, but they go to a FOI, we call it a FIPA department within the Ministry of the Attorney General. And frankly, I to this day have not seen the redacted letters that went to the Star. I don't even know exactly what was redacted out. So, no, I don't have that. I don't have any access, or I don't see those letters when they go from the Freedom of Information Department to, in this case, the Toronto Star.
Do you think it's justified to disguise or hide the names of police service boards that you wrote to?
Well, I mean, there's kind of two levels of answers to that. One is a legal one. I don't know what the law is with respect to the release of this material. Now, I should add, and you've raised a very interesting issue, should I be publicly indicating every time I don't lay a charge that there are problems in the investigation? I have done it in certain cases. The big one is working its way now into the Court of Appeal in the Schaefer and Minty matter to do with the use of police association lawyers in the writing up of notes. And that all started when I released a press release in 2009 with respect to the shooting of Levy Schaefer up in a very remote area in northwestern Ontario. I mean, I guess my attitude is, and I've got to say, I've been going through a bit of a rethinking, in part because of the Star articles. And you may call me naive. I thought I could work out a bunch of these issues with the police. And there are very receptive police services. For example, I received a call this week, unrelated to the Star article, from the chief of the Ottawa Police, who said he is going to be disciplining one of his officers for a breach of the SIU regulations. I mean, there are ways to deal with it, but I'm starting to realize that to some degree the Star article has crystallized this in my mind, is that it shouldn't really be a situation of relationships between me as a director and particular chiefs. It should be more institutional, that relationship. It should be that there is more institutional cooperation. It shouldn't be because I get along with Vern White in Ottawa, but I didn't get along with Commissioner Fantino. That's not the way things should work. So I'm kind of rethinking this, but I intend, when I'm of the view, this is kind of the criteria I'm trying to use of whether I go public with respect to cooperation issues. Do I feel that it's going to interfere, materially interfere with the fact process, the fact, search for facts, search in my view for the truth, process that I have to engage in to decide whether or not there are reasonable grounds to lay a charge? So I kind of set that threshold for myself, because there are frankly a lot of breaches that take place that at the end of the day may not matter that much. And I'm trying to frankly keep the powder dry. I mean, I'm trying to work things out internally with the police. And we've seen what's happened. It hasn't been terribly successful. It is successful with some of them. But I may change my view over the course of my order in council appointment. I'm halfway through it, and I may change the view.
Yeah, no, I think it's an extremely important point, and I think that Ian has been very brave in coming out, pointing out police shortcomings, and he's paid a price because, the police often take the position that if you're not 100% with them, you're against them. So I think that it serves the public interest and the public good to hear when things go wrong in a material way. So I think he deserves a lot of credit for taking that step since he's been at SIU.
Thanks to the Law Union and you gentlemen for being here. Certainly one of the benefits perhaps of all this G20 practice has been we might have a greater appreciation of wearing black and also being black. So let's hope. On a somewhat more serious note though, with the many perceived and alleged and real charter violations that occurred during that weekend, including a lot of roughing up I think that occurred off camera and behind the police lines, we've also had a situation where I believe a lot of the images and cameras have either been confiscated or deleted or tampered with. And I would hope and urge that all of you in your various explorations, you really look at and tabulate and catalog whatever instances you hear about so that we can actually document and have some credibility to some of these concerns about cameras being taken and damaged, if not stolen. Certainly, fundamental freedoms, everyone has the following fundamental freedom, including freedom of the press. And so that's a very fundamental thing that we have to defend as well as our individual liberties.
Okay, my question is just for Ian Scott. Basically, it's a two-part question. I'm going to keep it very quick and concise and clear. The first thing is about a comment that you made earlier when you're talking about the Adam Nobody case. You said that most people with footage like that of police violence would be afraid to come forward. And I'm curious as to why you think people would be afraid to come forward with footage of the police being violent. That's the first question. Second question is, in its 20-year history of the SIU, as of October 2010, there's been 3,400 investigations. Out of those 3,400 investigations, there's only been criminal charges laid in 95 instances. Out of those, only 16 officers have ever been convicted. And of those, only 3 officers have ever done any kind of jail time. No charges have even been laid in this city in the most blatant cases of police misconduct, such as with Jeffrey Rodica, who was shot to death by the police at the age of 17 years old, or in the case of Junior Manning, who was killed just last year when the police asphyxiated him to death. When we have the cops coming into our communities, brutalizing us in this fashion, betraying our trust, can you give anybody here one reason, given these statistics that I just gave you, which I saw you nodding along with, so I'm sure you're aware of them, why we should have any kind of faith in the Special Investigations Unit whatsoever?
Okay, that's a two-part question. Let me go to the first one. Well, I learned a lot actually about YouTubes and uploading. Apparently when videos are uploaded, they can remain largely anonymous. And you can actually communicate with the people behind the YouTube through their monikers, but there's no guarantee they're going to come forward. The only time John Bridge came forward was after the comments that Chief Blair made in the paper. There are other YouTube videos where people just simply aren't coming forward. It would be of great benefit, obviously, to the SIU if they would come forward in certain circumstances. But it seems to be pretty clear that people shot videos, they uploaded them, and for the longest time were not doing it in a way that they could be identified. And what I was trying to do was say, look, John Bridge had a choice. When he heard that program with Chief Blair, he could have ignored it. He could have said, I'm not going to get involved. I don't need the grief. What are the consequences? Maybe the police will come after me. I don't know. But he didn't do that. He did the right thing. He went to Julian Faulconer and he swore an affidavit, and for that he deserves credit. I think there's a lot of people that shot video down at the G20 that might not have done that. We wouldn't be where we are right now. Now, with respect to the stats you indicated, that obviously comes directly out of the Star articles that ran in October of last year. I'm not in a position to talk about what happened before my watch. I started about 2.5 years ago. I can't comment about charges that were or were not laid by prior directors. But I think, frankly, it's a little unfair to look at how many officers actually went to jail. Because the reality is, in these prosecutions, and I've been involved in many, many police prosecutions, first of all, the conviction rate is lower than your average one. Secondly, the police officers have a presumption of good character when they come to court. Thirdly, things changed radically in about 1997 when the conditional sentences came in. And if you have no prior record, unless you are found guilty of an offense that has a minimum sentence, it's very unlikely that you're going to go to quote-unquote real jail. Those stats are a little misleading because there's a lot of police officers who, after being found guilty and convicted, serve conditional sentences, which in law are jail time. So, you know, I mean, the Star took a little bit of liberty when they looked at that particular issue. All I can say is, now with the hat I wear as the SIU director, and, you know, it's really up to you whether you want to have faith in what I'm doing. That's your call. I can't make that call. I'm going to do the best job I can. And since I've got there, there have been, as I say, 25 charges laid. You can start tracking through the system. There were convictions found just a couple of weeks ago in both the Ing and Cruz matter after a very difficult trial by a very good prosecutor. These cases are litigated, I know because I've been there many, many times, very hard. The police association lawyers are well paid, and they have access to all kinds of resources that you don't see in a legal aid case. They are like walking through the looking glass when you're a prosecutor. And you may want to talk about having changes in the criminal justice system for police cases. I think the likelihood of that ever happening are next to nil. The reality is that police officers charged with criminal offenses are going to have exactly the same rights as everybody else, and I actually support that. I don't think there should be a two-tiered system. That's the reason why I, in certain circumstances, have suggested that there be an amendment to the Police Services Act to allow the SIU director to refer certain cases to a non-criminal forum for adjudication. Because there are going to be cases where perhaps that's a better forum to deal with. And there's an article which thankfully Kent allowed to be published in the Criminal Law Quarterly in 2004, which you can refer to if you want to look into that a little more.
Thanks. My question is for Gerry, because your organization is relatively young. And we got word in British Columbia that the provincial government is thinking about bringing in an independent investigations body for the provincial level. In light of what's happened with G20 and everything that you've experienced in the last couple of years, if you could turn back time to when your body was created and the statute that made it, is there anything that you would change or things that you would recommend to British Columbia in the creation of their body that would make your job more efficient or your body more effective?
Well, this is a very interesting question. I'm still learning myself. It's so new that I'm trying to work out on a clear understanding of what the legislation is. And I have, in fact, consulted already with British Columbia to some extent. And if there's anything I can tell them would be to try to get a little more autonomy in regards to the work that they're actually doing. I think one of the criticisms I have heard to date is given my staffing component and my inability to carry out all investigations of public complaints, that there seems not to be much of a change in the system, but there is. I'm monitoring it, I oversee it, I take action if I'm not dissatisfied with a complaint, I send it back to chiefs with specific directions. So one of the things I would recommend to them is to find some way that they can actually handle more of the complaints within that organization, that civilian organization.
Thank you.
First of all, I'd like to thank the Ombudsman for strongly criticizing the way the secret legislation was handled and coming out making a clear statement that the police clearly overstated their authority and criticizing the government for doing so. My question is a little more, I guess, to the point, but in Quebec, it was documented that Quebec police officers, with their boots and everything, went into the crowd and were trying to, like, throwing rocks and trying to, like, almost create a pretext for the police to come in and sort of beat up everybody. And there were similar allegations made up with the police at the G20, where there were people wearing police boots that went into the crowd, were causing trouble, looking like to give the police as an excuse to go and attack the crowd, and then these same people ended up going and disappearing behind police lines. Now, I think this is like a tactic used in authoritarian and dictatorial societies, and I think it should be condemned in the strongest possible way. In fact, it should be also criticized. In fact, these people should be disciplined, if not put in jail, because it's a very, very serious transaction on the part of the police to try to go and disrupt crowds. And this has happened time and time again. Now, I'm not 100% clear, but I believe that there were numerous reports that were credible that documented that this, in fact, took place. And I'd like to hear all four members of the panel about the use of this sort of tactic and what can be done to prevent it and to protect people from such abuses.
Well, if it did indeed happen, obviously it shouldn't, and it's a very serious issue. I don't oversee police in Ontario, so I will defer to my co-panelists.
What a segue. Look, I'm not about to comment on that, primarily because it's a matter that's coming under one of the terms of reference in regards to my systemic review, because my systemic review deals with stop and searches, arrest, use of force, and what the gentleman has described seems to cover the gamut of that. And so I prefer not to comment at this time so that I'm not perceived as making a pre-decision in regards to the outcome of my review.
That issue just did not arise in the 6 SIU investigations, so I'm not in a position to comment, sorry.
I'm in a position to comment. It's one of the wonderful things about being in private practice. Nobody pulls your strings but you. Obviously, the gentleman is correct, to me, and I don't think that police need to engage in those kind of tactics in order to do their job effectively. I think it's just a shortcut, and it's unnecessary, and it's unacceptable in a democracy. And as I said, I think there's a culture of complacency out there that the general public seems to think that the G20 excesses were necessary for the safety of the public, and the people who were the victims deserve what they got. There seems to be, I think that's why nobody's really doing anything about it. And on the previous questioner's comment about the police accountability and why it is that we can't get police prosecuted and so on for excesses. Well, there's a couple of things. One is that the law is, from the Ontario Court of Appeal, in a case called Gorvey, G-H-O-R-V-E-I, that when a police officer, there's been an adverse finding of credibility against a police officer in a certain case, and that same police officer engages in the same conduct again in another case, well, in that subsequent case, you cannot cross-examine that officer on the previous finding, adverse finding of credibility. And so I've learned this the hard way, because we have an officer in this very situation who did the exact same thing to another black kid, and the court rightly condemned the officer for it and found him not credible. And when I attempted to cross-examine the officer about that previous unrelated case, the judge cited the case of Gorvey to me, and I was precluded. The problem with that is that the law allows the conduct to continue and nothing is done about it.
That wraps up what I hope you think, I certainly think was an excellent panel. Thanks should really be said to Meg Daniel, who did all the heavy lifting in terms of organizing what I think was a great panel. So with that, we are adjourned, and thank you.
All right, Word of Mouth Wednesday. We're just here on U of T campus. We're actually in the Hart House. We just saw an event about the G20, and we got a guest here. Do you mind introducing yourself?
Peter Rosenthal.
And what did you think about the event?
I thought it was a very interesting event, and they're very interesting issues. Some issues weren't discussed that could have been discussed, including the fact, in my view, that a lot of the videotapes of the incident show that literally dozens or maybe even hundreds of police officers committed criminal offenses. Now, the SIU has a mandate of only investigating serious injuries or death caused by police officers, there were a lot of injuries inflicted by police officers that weren't serious or death. But the Toronto Police Service should be investigating those injuries, and they don't seem to. At least there are no reports of any officers being charged, except for the one charged by the SIU.
For real. And are you working? I know you're working as a lawyer. Are you working with the G20 issue at all? Do you have any?
Well, I have a couple people charged in the G20 who I'm representing, and then I have one or two possible civil cases too.
So, and I guess is it all unknown, like when all these issues are wrapping up? Because I know it's been like 8 months since the G20, and there's all this like new stuff's coming out and all this. Like, is there any time frame?
You're going to be hearing about the G20 for the next 3, 4, 5 years, I'll bet you.
All right, thanks a lot, Peter Rosenthal.
Civilian Oversight, G20.
Speakers Ian Scott, the director of the SIU, Andre Marin, Ombudsman of Ontario, Gerry McNeilly, the Independent Police Review Director, Roger Rowe, lawyer, Rowe Law, and the moderator, Ken Roach, University of Toronto.